Hi, I'm Ross Simpson.
And I'm Alec, and we're members of the Commercial Disputes team at Shepherd and Wedderburn.
In this video, we're going to look at privilege. The importance of establishing that privilege exists over key documents is that it allows an organisation to maintain a degree of control over the information that's passed to the court and to the other side. In Scotland, two grounds of privilege are recognised: legal advice privilege and litigation privilege.
Legal advice privilege, or legal professional privilege as it is sometimes called, is given to communications between a lawyer and client. The courts will only order disclosure of privileged communications between a lawyer and their client in very limited circumstances. For example, where the client waives the privilege. This privilege arises out of the relationship of confidence between a lawyer and their client and, broadly speaking, applies to the giving or receiving of legal advice about what should prudently and sensibly be done in the relevant legal context. Non-legal advice given by a solicitor can also attract confidentiality where that advice is given in the relevant legal context. This would include advice to a client on their best course of action, having advised them on the content of the law. Advice that is purely commercial would not be privileged, as it would lack the relevant legal context. Although it is sometimes referred to as solicitor-client privilege, it is in fact broader than that would suggest. It extends to communications between the client and the solicitor and their advocate, as well as their clerks or other staff. Legal advice privilege ends when the relationship ends, and communications made after the relationship ends are not covered by the privilege. However, the end of the relationship does not extinguish the privilege that is already attached to previous correspondence. This privilege survives the end of the lawyer-client relationship, and indeed, in some cases, survives the death of the lawyer and the client themselves. In Scotland, legal advice privilege is very unlikely to extend to other professionals beyond lawyers. For example, we would not expect it to extend to an accountant giving their client legal advice in the course of their work, or indeed any other advice. In-house legal counsel should take extra care, as their proximity to the business means that their role is quasi-commercial, and thus privilege would not automatically apply to communications between an in-house solicitor and the business. Difficulties can arise when trying to assert that a communication was legal advice and therefore privileged, as opposed to commercial advice, which would not be privileged. If an in-house lawyer forwards external legal advice to others in the business, then this could also result in privilege being lost.
Litigation privilege is a wider type of privilege and protects confidential material that a party has made in contemplation of litigation, where the material was necessary for the sole or dominant purpose of the litigation. Privilege attaches as soon as litigation is reasonably contemplated. The Scottish courts have taken a broad view as to when litigation is reasonably contemplated, and this may be wider than the approach taken by other jurisdictions. This is a question which will very much depend on the facts and circumstances of the individual case. But in past cases, the court has ruled that litigation was reasonably contemplated after an accident has occurred, or once the parties are at arm's length or are obviously going to be at arm's length. It is not necessary for proceedings to have formally commenced, although litigation must be a real likelihood rather than a mere possibility. Further, a communication made in contemplation of litigation does not lose that confidentiality if the litigation is concluded, or even if it never occurs. The starting point in Scotland is that the court process is open. The court rules are published daily and found on the Scottish Court's website, and they list the cases that are calling in court and in respect of which there may be hearings. Most hearings of the Court of Session, and indeed the Sheriff Court, are open to members of the public. Judgments of the High Court of Justiciary, the Court of Session, and Sheriff Courts, as well as fatal accident inquiries, are all published on the Scottish Court's website if they are of particular public interest or decide a significant point of law. A wide range of judgments can also be found in court reports and are accessible using services such as Westlaw and the Lexis Library. However, certain other court documents can only be obtained where the party making the request has put forward a proper basis for access. having regard to the statutory protections of the GDPR and Data Protection Act 2018, among others. Parties' names are anonymised only in certain circumstances, for example in family actions involving children, in some arbitration appeals, and in certain cases where an application is made to the court under the Contempt of Court Act 1981.
For more information on privilege, please get in touch.